Fighting for our community is something the law firm of Bordas & Bordas takes very seriously. The Ohio Valley isn't just a place where we work, it's where we live. That's why you'll see us fighting the battle against breast cancer, coaching youth sports, providing meals for those in need, and supporting our local YMCA. Bordas & Bordas, fighting for justice.
Hi, I'm Jamie Bordas. Welcome to the Bordas & Bordas Legal Review. Each week we talk to you about issues affecting our area, our state, and our nation. This week we're going to be talking about workplace injuries, particularly in light of the recent attention that coal mine injuries and deaths have received here in the state of West Virginia. With me here today to discuss it is my partner at Bordas & Bordas, Chris Regan, who's handled a number of workplace injury cases during his career. Chris, thanks for being on the show again.
Great to be here, Jamie.
You know, Chris, in the recent weeks, there's been a lot of attention given to the coal mines because of the deaths that have occurred. There have been 4 in West Virginia in the recent weeks, and it's even gotten the attention of the governor now, which it should. What's going on now, and what did the governor do?
Well, we've seen 4, as you say, 4 coal mining deaths in the past 2 weeks. We've seen 6 in West Virginia just since November, and these, I mean, that's just deaths, not injuries. And the magnitude of that led Governor Tomblin just the other day to declare what he called a coal mine safety stand down. Now, this can be a little bit misleading. This is not a stop of production. This is not an end to coal mining by any means. What it is a 1-hour safety stand down or safety process whereby before a shift begins, according to the governor, the coal mining operations are expected to review safety procedures with the men and review the safety conditions in the mine. It's not entirely clear what power the governor has to make sure that they do it, or what enforcement or checking up there is on that. But the governor nonetheless did issue the statement requiring that, purporting to require that of the coal mining operations in our state because of the rash of deaths that we've had.
You know, one of the issues, Chris, is that this is not the first time this has happened. Of course, Senator Manchin, then Governor Manchin, when he was governor, issued such a stand down after one of the tragic incidents in the coal mines that affected so many people in the southern part of our state. But it just seems as though one of the issues is that there'll be a stand down, and then it gets a little bit of attention in the aftermath, the immediate aftermath of a tragic event, and then things go back to business as usual.
Well, that's exactly right, Jamie. I mean, and that is a cycle that has been repeated in the state of West Virginia for, decades, if not really more than a century. I mean, a tragic incident occurs, and there's an immediate response of attention from political figures, from regulators, from the news media, and there's some attention from the public, but it doesn't last. And after a period of time, the exigencies of production return, and it goes back to business as usual in the mines, and which is why there has been just simply a cycle of coal mine disasters in the state of West Virginia, dating back to the 1800s.
You know, Chris, one of the mines where 2 of the deaths have occurred here in the last 2 weeks is the Pocahontas facility down the southern part of the state. I'm actually handling a case right now involving a miner who lost part of his leg as a result of an injury in the mine. And it seems like, some of these mines you see time and time again. I mean, that particular mine, I think, has been cited something like 65 times just in the last, several months here for safety violations. But this is, as you said, has been going on for a long period of time in this state. I mean, there are books written, you and I have become familiar with some of these as a result of handling some cases, but this particular book here, number 9, which is deals with the Farmington mining disaster back in 1968. It just recently came out, I think, in the last year or two. But it details, how these things can be prevented. And gosh, if just something simple had been done, for example, here, they turned off the alarms that would have alerted people that there was this buildup of gas that ultimately caused the explosion that killed all these people. But the alarms have been turned off because they were annoying, because they were going off at times when they shouldn't be going off. So they just got too annoying. They turned them off, and then lives were risk because of it. But this is a good book if people are interested in the in some of this history of the coal mine incidents in this state. It's called Number 9. It's written by Bonnie Stewart. You can get it online, but you've read this too.
I have, Jamie, and that's another common pattern that we see. At Number 9, there are these huge fans that are supposed to ventilate the mine, make sure that there are no buildups of toxic or explosive gases, and when the fans shut down, alarms are supposed to go off in the control room. And then people don't shut them, they shut the alarms off because they don't want to hear them, because the fans are off, and the next thing you know, you do have those explosive gases building up, and the results very deadly there. I believe something like 39 miners killed in the Farmington incident. There's also another book by Gerald Stern called The Buffalo Creek Disaster, where a slurry impoundment dam collapsed and caused mass civilian casualties, not only deaths to the miners, but civilian casualties as a result of similar type of conduct. They had had several dam collapses in the past, and they didn't take any action on it, and then when one finally collapsed that had a town downstream, it was nearly wiped out by what happened. The Sago disaster, the Upper Big Branch disaster, not all that different. In Upper Big Branch, it was coal dust that was not appropriately controlled, not rock dusted as is required to be done in the mines, and they were consistently cited, as you said, not just 1 or 2 times, but 60, 70, 80 violations of the regulations had occurred, and yet no action was taken, and then ultimately you have an explosion. 22 or 23 miners there, if I'm not mistaken, killed at Upper Big Branch. And after each one, the hearings, the publicity, the news stories, the weeping family members grieving on television, but 6 months, a year later, what have we done? Not enough.
There have been some legal developments recently relating to coal mine safety, or things that will hopefully help coal mine safety. What are some of these recent developments in the legal world that may affect this?
Well, 2 worth talking about for sure, Jamie. One is the decision of the West Virginia Supreme Court of Appeals in Bragg versus United States, and in that case, what our West Virginia Supreme Court of Appeals said in answering a question certified to it from a federal court is that it is possible under West Virginia law to hold mine inspectors liable, legally liable in damages for failure to do their jobs properly. So if the mine inspectors are negligent, if they go into the mine and turn a blind eye to violations, if they inspect casually or inappropriately or carelessly and don't write up the violations that they see and hold the mining operations feet to the fire, that can be negligence on the part of those inspectors, and they can be held legally liable for failure to do their job, which is, I think, a positive development, because we've seen it again and again. The inspectors and the coal mining operations can become just too cozy of a working relationship there, and when that happens, you don't have enforcement of the rules, and the disaster inevitably results. So Bragg versus United States, I think, is a case that people will be hearing about, and it's a good step forward for accountability in our state in terms of coal mine safety.
And of course, in those instances, it's not just that if something happens that the mine regulators are automatically liable or responsible. They had to have done something wrong or inappropriate or negligent with respect to the handling of their duties in order for the case to be able to proceed against them. And that has to be, of course, looked at by a judge and determined and proceeded. Then it can go in front of a jury. That's
exactly right. There has to be underlying negligence or the failure to perform a reasonable inspection. So it wouldn't be, if the mine inspector does a reasonable inspection that's appropriate under the guidelines and regulations, then he's not going to be liable. But if his inspection is unreasonably dangerous, careless, not living up to the standards that exist for mining inspectors, then he can be held legally liable. And that was a case arising out of an Aracoma mine disaster where 2 men, one named Bragg, the other I believe named Hatfield, were killed. And their wives sued the mine inspectors and sued the United States as the employer of the mine inspectors for not doing their job. And that's a significant legal development, to have it established that there is going to be liability in that situation on the folks doing these inspections, not just the mine investigators themselves.
They said there were a couple of recent legal developments, one being the Bragg versus United States case that you just talked about that was handed down by the West Virginia Supreme Court. What's the other?
Well, the other thing that I've noticed, Jamie, that I think is a bit of a change, is our federal prosecutor, United States Attorney Goodwin, in the Southern District of West Virginia, has brought some more substantial prosecutions than we've seen in the past regarding management, foremen, and other individuals under the control of the mining companies who fail to enforce the safety rules on their shifts, but even more significantly, defraud or attempt to deceive the mining inspectors and investigators. What we saw was they were tipping off folks that the mine investigators are here now, so we need to dress the mine up as though the safety regulations are being followed. And then, of course, once the investigator leaves, everything just goes back to normal. And there was even some, I mean, and this is scary, it's disturbing, collusion, where the MSHA investigators would tip off the mine foreman that is a buddy of theirs, hey, we're going to be coming on such and such a day, so try to have your ducks lined up in a row at least for that day while we're there, so we can get you through this inspection without too many violations. And that's just, I mean, a disaster all around. Now you have everybody who's responsible for safety trying to make things not safe, basically, trying to make things look safe when they're not. And there's been some prosecutions that have uncovered that conduct, and it's moving up a little higher up the chain. I mean, I think everybody would like to see the highest executives of the coal companies held accountable. That hasn't happened yet. But at least United States Attorney Goodwin is moving up the chain there and trying to get some accountability criminally for irresponsible conduct in these mines.
You know, one of the things, Chris, you know, the people, of course, our state is a big coal mining state. There's a lot of people that make their livelihood from working in the coal mines. And the idea is not, of course, by United States Attorney Goodwin or anyone else to shut the mines down. It's to, hey, if you're going to mine, that's fine, but let's protect these people that are working in the mines that don't really have the ability to speak up themselves, because they lose their job.
That's right. There's tremendous fear of anybody losing their job in this economy. And so you don't have folks who don't want to speak up. They don't want to be a whistleblower. It's very difficult to survive as a whistleblower, because you can lose your employment, you can lose your reputation, you can be blackballed by the mining companies and prevented from gaining employment with other companies. And so it's a very tough situation, particularly when we have a bad economy, for people to come forward. But, I mean, you know, the question just becomes is, how long are the miners going to be considered by these companies a waste product of mining? Just something that we have to accept as a way of life, that these men, like the gob itself, are just thrown on a pile as a cost of doing business. You know, how long can we live with that? You'd like to think not much longer.
Well, we need to take a break here on the Bordas & Bordas Legal Review. When we come back, we'll continue talking about workplace injuries. We've been talking about coal mine safety. We'll talk about what someone can do if they're injured in a workplace setting, or if one of their loved ones can do if they should happen to unfortunately or tragically lose a loved one as a result of an injury in the workplace. Stay with us in the Bordas & Bordas Legal Review.
Fighting for our community is something the law firm of Bordas & Bordas takes very seriously. The Ohio Valley isn't just a place where we work, it's where we live. That's why you'll see us fighting the battle against breast cancer, coaching youth sports, providing meals for those in need, and supporting our local YMCA. Bordas & Bordas, fighting for justice.
Welcome back to the Bordas & Bordas Legal Review. I'm here today with my partner, Chris Regan. We're talking about workplace injuries. So far in the show, we've been focusing on injuries that have occurred in the coal mine, particularly in light of the recent deaths that have occurred in West Virginia tragically as a result of some of the lack of safety measures in place at some of the coal mines. But Chris, I want to turn our attention to talking a little bit about what family members or a person himself who is injured in a workplace setting can do, because you've handled a number of cases like that in West Virginia and Ohio. And before we get into what someone can do with respect to their own employer, let's talk about the fact that sometimes someone is injured in the workplace as a result of someone else's conduct or some other company's conduct, because that company may have put a product there in their workplace. That company may have, there may be someone from a different company working alongside someone. In those types of settings, someone can proceed with still filing a lawsuit as a result of their injuries or to recover their damages.
That's right, Jamie. I mean, you know, one of the most critical roles that you and I play as attorneys for people who sustain injuries in the workplace is determining who is the responsible party, who is the negligent party, the person at fault in causing the injury. And that has to be a very thoroughgoing and detailed investigation. Frequently we hire engineers, we hire OSHA personnel, safety experts, to analyze a situation where there's a workplace catastrophe or injury and determine who is the responsible party. And workers' compensation creates a partial immunity for a person's employer. such that there's a higher bar for suing your employer than just suing another company that happens to have injured you in what they call a multiple employer work site. So for example, in a case Bordas and Bordas handled in 2007 through up through the present day, American Electric Power caused a hydrogen explosion at the Muskingum River plant down in Beverly, Ohio in 2007. And there was a worker who was injured who was working for another company at the plant at the time. That worker, who was actually killed as a result of the explosion, he is not covered by workers' comp through AEP because he doesn't work for AEP. And correspondingly, AEP doesn't have any workers' compensation immunity. So he's able to sue AEP, or his heirs, of course, are able to sue AEP for wrongful death. And workers' compensation doesn't come into it. Now, by contrast, the plant employees of AEP who were injured in the hydrogen explosion, they are covered by workers' comp. And so they have to prove a higher standard of what you call deliberate intent or intentional injury in order to successfully recover against the company. Otherwise, they're limited to a relatively small workers' compensation check.
Well, I think that's an important distinction because a lot of times people think, well, boy, I was injured on the job, so workers' comp must be the only remedy available to me, and that's not always the case. As you've just pointed out, if someone is injured through the conduct of some other company, they can proceed in the courts like they normally would. But also, as you just pointed out, even when someone's own company, let's say there's no other company involved, no other people involved, just the person's company, even when it's just the person's own company involved, there are times where the workers' comp immunity does not apply, and that's in a setting which we would call a deliberate intent case. And deliberate intent's been around for a while. How'd that come to be, and what's the history of that?
Well, deliberate intent was essentially a response to the harshness of workers' compensation immunity. Essentially, the worker was left without any remedy over and above workers' comp, which is, again, a fairly modest form of compensation, not the full damages one would normally be entitled to in court, in order to provide some predictability and certainty. And what the worker gets in exchange for that is he doesn't have to prove fault. If you're hurt on the job, typically, unless there's special circumstances, you would be entitled to your workers' compensation. But it is a very modest remedy, and it doesn't provide a lot of deterrence for the company for serious safety violations. So once that system was implemented, we began to see certain situations where a worker was hurt through egregious misconduct, reckless behavior, total ignoring of clear safety rules, resulting in injuries and deaths and catastrophes. And then the deliberate intent exception came to be. It was first adopted as a common law process through our courts, and then was later codified into statutes by our legislature. And it essentially says that where the reason the worker was injured is aggravated negligence, either egregious recklessness or actually intentionally causing the injury to the worker, then all bets are off in terms of immunity. The employer then becomes subject to the full lawsuit damages that we normally expect in terms of all your lost wages, the grief of your survivors if you are killed, your pain and suffering, your loss of your ability to enjoy life, and so forth. That comes into play against your employer only if you can show that deliberate intent scenario that we've been discussing.
And Chris, we've seen that through our careers where there have been situations or cases where there will be a company who knows about an unsafe working condition. They've been told by maybe multiple employees that, hey, this is unsafe. We can't keep this way. Somebody's going to get hurt. And yet the company continues the practice. And then unfortunately, someone does get hurt. Someone does get killed because the company refused to change that practice and forced the person into that unsafe working condition. And it is a heightened standard, and because of that, they're very difficult cases to handle, difficult to meet that standard. But when a company when it's able to be shown that a company does have those practices in place that are unsafe, it's only right and just that the person or their family members be compensated as a result of the terrible consequences that occurred.
Oh, absolutely, Jamie. And your discussion of that puts me in mind of the Scotty Evans case that your dad handled for our firm back in, I think starting in about 2004 through, I think it was about 2004 that case was resolved. And Scotty Evans was a garbage truck driver working down in Marshall County, West Virginia. And he was with a fully loaded, in fact, heavily overloaded garbage truck on top of Roberts Ridge down there in the Moundsville area, and basically was ordered by his superiors at Allied Waste to take that down from the ridge to the low-lying land on an incredibly steep and difficult road to drive with an overloaded truck. And we secured the testimony from former employees and even some current employees that the trucks were not appropriately maintained, the brakes were not appropriately greased, and replaced. Parts were not replaced that needed to be replaced, and so they weren't performing properly. And ultimately, the transmission itself had problems from overuse and also not being properly maintained. And as a result, it was basically sending the man to his death. There was no way to control the overloaded truck on that incredibly steep ridge, and as he came down and tried to make a turn, the truck was simply carrying too much speed. He went over the edge and was killed. He left a wife and two very heartbreakingly young children behind, and your dad executed that case over a number of years with just the things I was talking about before. Engineers had to be called in, the transportation experts, people who were experts in trucking safety and in trucking maintenance, and they looked at the whole situation and said, yes, this was essentially deliberate. The main consequence of sending him down that ridge in that truck was going to be to getting him seriously injured, if not killed, and of course the worst occurred. So that's the kind of situation that can lead to deliberate intent. There can be many others, but that's the kind of work you have to do to establish a deliberate intent case, and obviously your dad did an historically great job in that case.
Well, one of the reasons those cases are especially difficult, like so many of the ones that we handle, is that there's a lot of expert testimony in those cases about the different components of whatever it may be, someone's job, in that case a truck. But and of course, it's these companies that are multi-million dollar companies, sometimes billion-dollar companies, have all the money in the world to hire experts and fight it. So you really you have to be ready for that challenge and ready to take it on. And fortunately, in that particular case, like so many we've seen, we're representing a good family who has faith and confidence in us, but also there were a number of former employees of the company who were willing to step up and tell the truth about what had happened. And that's one of the biggest things, is getting the investigation early and finding out who the other people were that worked for this company that may be able to tell you, hey, this is what was going on here at this company. And some of them, as you said, were even current employees still. And, it took a lot of courage on their part, I think, to testify and tell the truth with respect to what their employer was doing.
Absolutely. I mean, that type of testimony is critical. I mean, people do need to be honest about what happens in these situations, because if they don't, there can be no justice at all for the victim. But one of the other things you mentioned, really sticks out there to me, which is that a lot of these industrial sites seem extremely complex. Whether it's a mine with mining machines and scoops and lifts and all sorts of things, people are not used to, if you're not a coal miner yourself, you've not been down there, you don't know what you're looking at. These power plants are enormous. They have all kinds of systems going on. You really need expert help to pull that situation apart, because when you really learn the details of how work is supposed to happen at these sites, you find that things that look like an accident aren't an accident at all. They're in fact extremely predictable, and you have to dive into books this tall of rules and regulations that experts have developed over decades to help make these workplaces safe, and then you find out that the regulations are just being disregarded because the company wants to press forward with more production. Let's go faster, let's do more, let's cut corners, let's slap a Band-Aid on this broken piece of equipment and move on instead of fixing it right. And we've even seen literal memoranda from companies where people were pointing that out, and then it still doesn't get done because the almighty dollar tends to rule those situations.
Yeah, that's part of the challenge, but yet sometimes fun part of our job is we have to become experts on things like hydrogen plants, things like trucks, things like insurance company inner workings, medicine, all these different things that these cases we handle. If we're going to question these witnesses, of course we have to get up to speed on it and know exactly what we're talking about. Otherwise, they can trick us. We wouldn't even know it. So that's part of the like I said, the challenging part, but also the fun part of the job. So I appreciate you being here today to discuss these workplace setting injuries with our viewers. I think it's something that a lot of people encounter because so many of our viewers are out there working in different job settings, and particularly here in the Valley, a lot of those settings are industrial or perhaps even coal mines with a lot of the folks. So I appreciate you taking the time to talk about it to our viewers about that.
Well, it's a pleasure to be here, Jamie, and I hope your viewers will keep those coal miners' families in their hearts, because they're going through an experience nobody should have to.
Absolutely. Well, thanks to all of you for being with us here today on the Bordas & Bordas Legal Review. Join us again next time.